Welcome back to This Week in Immigration. I'm your host, Jack Malday, Associate Director at the Bipartisan Policy Center. Today's episode dives into one of the most talked about areas of US immigration policy, the H-1B visa lottery. First, we'll speak with immigration attorney Angelo Paparelli about the lottery's history, recent changes, and reform ideas. Then we'll be joined by Jeremy Neufeld of the Institute for Progress, who has written extensively on alternatives to the lottery. So stay tuned.
Welcome back to This Week in Immigration. I'm Theresa Cardinal Brown. I'm delighted to welcome to our first guest, Angelo Paparelli. Angelo is an immigration lawyer with decades of experience advising businesses, professionals, and organizations on U.S. immigration matters. He is currently a partner at Vialto Law, a global mobility firm, and blogs on immigration at nationofimmigrators.com. We'll talk to him about how the H-1B lottery came to be, key policy developments, and what might lie ahead. So, Angelo, thank you so much for joining us.
I'm delighted, Theresa.
Well, let's jump right in. So let me ask you, because we hear a lot about the H-1B lottery. Now, there's two lotteries in immigration. One is a green card lottery. We're not talking about that, but we're talking about the lottery for H-1B visas. Can you tell us what the H-1B lottery is and how it got started?
Let's go back to 1990 when Congress established the H-1B visa program and announced pretty much out of thin air that only 65,000 H-1B visas could be issued per year. Over the years, Congress changed that number. In fact, in fiscal years 2001 through 2003, it increased the number to 195,000 per year, which was interesting because in those years, the full allotment was never used, such that a lottery would not have been necessary. And as we discuss this, I will suggest that perhaps we should consider that approach again. But later in 2004, Congress added an additional 20,000 numbers. So the total is now 85,000. That 20,000 is allocated to graduates of master's degree programs out of U.S. educational institutions. And it has remained that way for several years. However, since about 2010, the numbers have been in excess of the 65,000 plus 20,000 allotment. And so the agency has had to initiate a lottery system. The lottery system eventually transferred over to an electronic registration system. The electronic system that has been in place for a few years now has had its own problems, not so much because of the system itself, but because of the structure of the system. The initial structure allowed multiple entries for the same individual by multiple countries. And it had the effect of gaming the system, where some individual H-1B beneficiaries had an advantage and a higher likelihood of being selected in the lottery. But last year, USCIS adopted a beneficiary-centric selection process. And under the new system, each beneficiary will be unique by reference typically to passport number in the selection pool. And regardless of the number of registrations submitted on that individual's behalf, they only have one chance in being selected. This mitigates the advantage that they previously held, where they could have multiple registrations. However, they can have their name submitted by multiple employers. And ultimately, the USCIS will make the selection. That's the United States Citizenship and Immigration Service, the agency within the Department of Homeland Security that manages the lottery. And then there is a notification process if someone who has been registered in multiple instances by various employers is selected. Every one of those employers can file an H-1B petition, but obviously the beneficiary gets to select employment only with one employer, unless the petition was for part-time employment, and then concurrent employment could be allowed, but that's rare. And so the other thing that's changed is that last year, the cost of registration was only $10. This year, it will be $215 per registration. So there's an economic disincentive in petitioning. But the effect of the lottery, as it's been recently operated, has been to cause employers to petition for far more people because they don't know who will be selected. It would be ideal if the employer got, let's say, 3 selections and could choose the 3 most desired employees to sponsor, but it doesn't work that way. So that's the current system. It presently gives people either a 1 in 5 chance or a 1 in 4 chance of being selected, and that will vary by demand.
Yeah. So when you say 1 in 4 or 1 in 5, that means 4 or 5 times as many petitions are filed as that 85,000 visas allowed each year.
Correct.
And
Correct.
that's why the lottery. The other thing I want to point out, and I think it's worth discussing, is that there's a timing issue here, right? So initially, the H-1B visas, as you mentioned before we hit the caps, they were processed first in, first out, right? And
Yeah.
people would file throughout the year. But what started happening is the demand went up. There's this period you have to file. You can only file certain period of time in advance. The new visas are available in the fiscal year. Tell me about how that sort of created this.
Sure. During this month of March, employers are scurrying with their immigration counsel to submit registrations. On April 1, the selection process begins, and shortly thereafter, USCIS will announce those who may proceed with an actual full-blown H-1B petition that demonstrates that both the job opportunity and the individual's background qualify as what is known as a specialty occupation. But the employment cannot start until October 1, which is the beginning of the fiscal year. So not only is there a limitation on the number of visas, there's also a delay in accessing these workers by operation of the fiscal year start date.
Yeah. So let's think about the consequences of this now. So you have some employers that file a lot of petitions for a lot of people, not knowing how many are going to get selected. You probably have other employers who say, I only need this one person, and they're in the lottery as well, and they don't know if they're going to get that person. Oh, and by the way, even if you're selected, you're not going to get them for 6 months at least, because it may
Right.
take longer if they're outside the country. And when they come in, you still have to have that job ready for them.
Yes.
Is that how I
Yes.
understand it? Okay. Want to make
In
sure I get this
fact,
right.
there is a prohibition against what is called benching, which is failure to pay the required wage, which is the higher of the prevailing wage in the geographic area or the actual wage paid to similarly qualified employees in the same job at the same work site. And so if you don't pay the wage, once the person comes in, there's a 30, 60-day window, depending upon the manner of entry or change of status. But then you're fined for not doing it. So employers have to be in readiness to have the job available and be able to pay the wage that is required.
Yeah. So there's been a lot of folks who have said, look, whatever you think of the H-1B program, this randomized lottery is probably not the best way to determine who should be working in the United States. From your perspective, as somebody who files a lot of these petitions on behalf of employers, has done this for a long time, what do you find are if there are any benefits to the lottery or drawbacks to the lottery? What for the employers and for the workers? From their perspective, what are the challenges with this whole system?
Well, the challenge is the uncertainty. One is presumably at one's desk, whether that be hybrid, remote, or at a work site, and wondering, am I going to be selected? Many of the beneficiaries are F1 students, academic students who have what is called optional practical training for either a 1 year or a 3 year runway. And so those who are in STEM fields get a longer period and more opportunities for selection. But there's a lot of angst on behalf of the employer that is investing resources in training and upskilling this worker, and in the worker himself or herself. And so it is not an ideal situation. As I suggested in those blessed days when 195,000 numbers were available, there was a lot less uncertainty. But the interesting thing is that there were years where that number was never reached because there just wasn't demand in the labor market at that time in those locations where people were sponsored. And so I think that's instructive that the lottery itself is an artificial constraint. And as we discuss later, I think we'll talk about alternatives that may make more sense.
Yeah. So you mentioned some of the recent changes to how the lottery is administered, and those changes were part of a regulation the Biden administration put in place at the end of their tenure. Can you talk a little bit about that regulation? And besides the changes to the lottery, what other changes did it make to the H-1B program, and what were they trying to do?
Well, these changes, known as H-1B modernization, and I don't know whether that's the right term or not, but they took effect just a few days before President Trump took the oath of office. And I believe by now the period in which those could have been subject to the Congressional Review Act may have already passed. But it's a mixed bag. Of changes, and some of them, I think, as we'll discuss, might very well be seen as quite attractive to the Trump administration. Others would be less so. But in terms of the positives, for the first time, USCIS has expressly acknowledged in a regulation that a non-citizen H-1B beneficiary can have a controlling interest in a startup company and sponsor, be the beneficiary of an H-1B visa. There are some constraints. Normally, an H-1B is granted for an initial period of 3 years, but in the case of a beneficiary-owned startup, it would be 18 months. The owner must have a 50% controlling interest, and while they can be engaged in actually running the startup, they must be primarily engaged, which is interpreted as 50% plus of their time must be using their specialty occupation. And so there's going to have to be a demonstration of the allocation between management time and specialty occupation time. Another good thing, I wish it were actually in the text of the regulation, but it is found very clearly in the prefatory comment, the supplementary information that accompanied the publication of the modernization rule in the Federal Register, that USCIS will now accept in lieu of education. So normally a specialty occupation involves the theoretical knowledge gained at the university level, resulting in at least a bachelor's degree. Now it is recognized that alternative training programs, skills-based learning can be a substitute for university education. Now, we've always had the equivalent. So if you had, for example, 3 years of progressively responsible experience in an occupation, that might be considered the substitute for 1 year of university education. So a person that had 12 years would have the equivalent of a degree. But this says something different. You don't have to have any degree or experience, but you can have skills-based learning having been acquired. So that's a positive change. Another very positive change is known as the deference rule. And basically that says that if the same employer petitions for the same individual to hold the same job at the same location, then the agency, in the absence of material error or material change in circumstances or eligibility, would not require substantial evidence to prove eligibility. They would defer to the earlier officer's decision that this person having gotten a petition to change or amend status, is still qualified. And that's not just limited to the H-1B. It covers the gamut of all employment-based non-immigrant visas that are used on the petitioning form. So that's a good change. It will eliminate the burden of voluminous evidence having to be submitted every time an extension is required. And an extension is required if there is some change in circumstance. So that will yet to be played out. But there are a number of negatives. One is the notion that there must be a direct relationship or a nexus between the field of study and the job duties. And in today's economy, multiple fields of expertise that are resulting in the conferral of university degrees can lead to a relevant skill set necessary to fulfill a job. And so, just to give you an example, you may have an accountant, you may have an economist, you may have an MBA, all of them able to fill a particular job in business. And USCIS has said that they will require a direct relationship between the degree and the duties of the position. And it's not just the job, the university title, the degree title, or the job title. It's looking at the actual studies and looking at the actual duties and making that nexus. But if a particular job might qualify under a variety of degrees, then each of them has to be proved to have that direct relationship, which will likely be burdensome. I might mention some other negatives, though. There is a requirement now to prove maintenance of status. Now, status is behavior after admission in a particular non-immigrant visa category. So it's a conduct-focused activity. But H-1B beneficiaries might have been in the U.S. for multiple years in different visa categories, and the current employer may have no access to the record of their historic entries and departures. And certainly there's also a question of how far back is the status? Is it the first entry or the most recent entry? So USCIS was asked to clarify that, and it vaguely did by saying that 2 paychecks might be enough to prove status, but that doesn't really prove status. So we'll wait to see. Another one is third-party work sites. The requirements of the contracting party, namely the customer, will determine if there's that nexus to a specialty occupation, even though the duties that are assigned may be pursuant to a contract that have nothing to do with the functions of the organization, but actually, for example, improving a software application used at the organization. But a couple of really bad things, and this is something I've been passionate about, is the expansion of the role of a unit within USCIS known as Fraud Detection and National Security. This USCIS was created with the Homeland Security Act of 2002, as was Immigration and Customs Enforcement and Customs and Border Protection. They trifurcated the old INS into these 3 distinct units, and USCIS was only supposed to do adjudications and naturalization decisions. But from the very outset, the initial director, Secretary of Homeland Security, gave USCIS authority to do investigations. And so the site visit program began. And these are unannounced site visits where a government officer just shows up unannounced for what the agency says they want, an unrehearsed encounter between the interrogated party and the government agent. And this is a problem because they've now extended it to customer locations, and the customer may not know anything about the H-1B workers' petition or what was said. But even worse, they've said that unannounced site visits can occur if an H-1B worker is designated as working remotely from their home, even if in their personal residence. Now, it becomes worse when you see that the Secretary of Homeland Security recently deputized FD&S agents to serve as ICE agents. And ICE agents are conducting investigations and apprehensions all the time. Now, if you can imagine a multi-unit apartment complex where one worker in an apartment is an H-1B worker, but others may be undocumented, and some people are saying, don't open your door. But if you don't open your door to the FDNS agent, you will have your petition revoked. So it's a very problematic situation, and USCIS basically turned a deaf ear. Those are the highlights of the
Yeah.
modernization rule, but
So,
those are,
so a couple of the things that you mentioned are related to this sort of third party placement, remote work. These are things that I guess, for some people, there's been a lot of conversation about how H-1Bs are taking jobs from US workers. And a lot of that has to do with what's called outsourcing, right? A company
yes.
decides that we are going to contract with somebody else to do our human resources function or our legal function or our IT function. And a third company, a different company, may send worker to the work site to do that work, but they're not employed there. This has been something that's been, I would say, controversial, at least in the H-1B program for a very long time. A few years ago, people may remember there were stories about Disney laying off workers and hiring companies, or Edison Electric. But these rules are trying to address that. But we also have this situation now where, as you mentioned, this third party may not even know that the person sitting at the desk in their place is an H-1B worker, and you have investigations coming. Or you have a person who's allowed to work remotely for another company in their home. Is it your sense that just like the H-1B category as designed was kind of an ill match for these kind of new employment realities?
Well, that's exactly it. When Congress created the H-1B, there was no phenomenon of remote work in 1990. I don't know when the internet was born, but I think it was after
It
1990.
was in its infancy in 1990, I would say,
Well,
probably.
maybe a few defense contractors had access to it, but the general
Yeah.
public did not. And the point that I would make is that this is not an unusual phenomenon where technological advancements outpace legislation, and then Congress has to play a catch-up or remedial role in trying to figure out what is the best solution. And the pandemic uh, accentuated these differences where everyone was working from home for a time. And some of these things are rather absurd. One of the things that's involved with the H-1B is a notification to the public that an H-1B worker will be introduced into a work site. Well, what does that mean when the work site is your kitchen or your bedroom? Do you post a notice on the refrigerator? I mean, that's how absurd it's gotten, that in order to have on its face compliance with regulations that were written before these technological advancements arose, we have systems that just don't quite fit, and you have to parse the words and say what's a reasonable compliance measure.
Yeah. So you mentioned earlier that you think that this regulation has now exceeded the CRA. And for our listeners, that's the Congressional Review Act, which is a law that allows Congress to undo certain regulations that a previous administration had done in sort of the last part of its term. And there's some timelines associated with that. But whether or not Congress undoes this regulation, certainly the Trump administration, if it wanted to, could rewrite the rules. It could propose new rules. Based on what's in the regulation, do you think, and what we know of the Trump administration's positioning on these things, do you think the Trump administration would look to revise or undo this particular regulation?
Well, we do have an initiative that occurred that didn't quite come to fruition under the first Trump administration, which was a dramatic ramping up of the required prevailing wage for job levels that would have resulted on average of a 33% increase in wages for workers who were often entry level, and it wasn't within the market of what employers in particular geographic localities were prepared to pay. And so I wouldn't be surprised if that came back into practice. And I might mention, we talk about regulations, but last week, Secretary Rubio, Secretary of State, made a pronouncement that was rather profound, suggesting that everything relating to the status, entry, and exit of people into the U.S. is a foreign affairs function and purporting to find an exemption from the usual rules of the Administrative Procedure Act, which gives the public a right of notice when proposals are going to be suggested in the form of regulations and an opportunity to comment. It also gives parties who feel that they are aggrieved by final agency action the opportunity to go into court. But there is an exemption for foreign affairs functions. And so it is possible this may be a precursor to rather short-term, immediate promulgation of new regulations. We have to wait and see.
Yeah. So getting back to the H-1B lottery, and this is related to the wage issue you just mentioned, there's been a lot of different proposals on what to do about the lottery. You mentioned, of course, one of the obvious ones is if you increase the cap and the cap is now bigger than the demand, we may not need a lottery. But if there's always going to be sort of more demand than visas, let's just say, there's different concepts of what you could do to allocate those visas in a different way. A couple of episodes ago, we had folks on from the Economic Innovation Group. And later in this podcast, we're going to talk to Jeremy Neufeld of the Institute for Progress. Both of them suggest sort of a compensation-based prioritization. And this gets to a concept that is attached to the H-1B program a lot, at least in public discourse, that it's really for the highest of high skilled, the best of the best. And how do you prove that somebody's the best of the best? Well, one of them is they should be highly paid. There's also the idea that if somebody has a really high compensation level, that is a proof that the employer is really wants them and they're not just trying to, undercut a US worker by hiring somebody who's cheaper. That's one idea, but what do you think about that or other reform proposals that would prioritize, say, STEM H-1B workers over other H-1B workers, or based on some sort of level of skill that they might have? What are your thoughts about those or other, or do you have other ideas of reform proposals?
Well, first of all, let's put this H-1B provision in perspective. Less than 1% of total professional workers in the United States, according to Department of Labor reports, are H-1B workers. And so this is an infinitesimal effect on the entire labor market. But beyond that, the economic advantages of H-1B workers are so great, as many, many scholars and research studies have shown, that American workers are the beneficiaries of job creation and the contributions to the Social Security system are material contributions, so that I will go back and say, this doesn't make a lot of sense. Bear in mind that there is an entire category of exemptions from the lottery that deals with research and academic institutions. And there's not been perceived to be much harm associated with any of those. So I would start with that. But if you start using salary paid as the metric for who gets an H-1B, that's a crude metric in my mind, because it will eliminate the startup entrepreneur. It will eliminate the pathway that students use to achieve benefits. So reforming H-1B in isolation, without regard to pipelines of talent that come at different levels and in different sets of skills, is sort of a fool's errand, because it's not going to solve the problem. One of the things, I listened to that EIG podcast. I thought it was excellent. But one of the things I would suggest is let's give the states more authority in the immigration space by not so much a heartland visa, but by allowing states to serve as economic laboratories to identify in their own populations, maybe at the county level, talented business proposals that would spur job creation and economic growth, and let there be competitions within each county. And the county can nominate those who they think are the best situated, basically by visiting folks on the ground and examining what's what. And then USCIS would just serve as a vetting agency to make sure there are no national security or other threats by the entrants who would come in. That would be the way I would recommend doing it. I would also say that for those that criticize the current H-1B program, I would suggest they really don't understand it, because there are many mechanisms in the law now to allow for complaints if there are abuses. And the Department of Labor simply hasn't publicized that very much, nor have they reported the civil fines imposed or the frequency of debarment, which are penalties that exist. There are multiple parties that can be aggrieved claimants under the H-1B program. So if there are abuses, publicize the vehicle of filing a complaint and receiving damages and having civil fines and debarment imposed, and the program would work as it is. That's why I would just say increase the number and let the magic flow from that.
Yeah. One other thing that I would point out is that, for the very highest qualified people, there's actually a whole nother visa category that's
Right.
not capped called
The
the
O1.
O1, right? The O1A is for people of extraordinary ability in the arts, sciences, business. It also covers athletics, and it's called the Einstein visa, but you don't have to be an Einstein necessarily. But if you are that highly skilled person, that's another visa category.
There are
And so,
multiple categories. There is the J1 researcher. There is the L1 intracompany transferee, and certain countries have negotiated treaties that give what are called e-visa benefits. And so to focus only on the H-1B and act as if this is a particularly egregious pimple that needs to be lanced seems to me to be a misguided understanding of the entire system.
yeah. It is interesting to me, though, that, since the H-1B category was created almost in 1990, at least since the mid 1990s, there have been these various proposals to reform it and change it. And there's been some legislation, as you mentioned, the bills that increased the cap also made some other changes to the labor condition attestations, the wage. We've had some changes over time. There's been bipartisan legislation introduced over the last several Congresses to further reform the H-1B category, in part to address what are perceived abuses. A lot of them are the outsourcing, those kinds of things. Do you see any prospects for legislative H-1B reform under the Trump administration, the current Congress, or in the near future?
Well, just recently, Jim Jordan, the chair of the House Judiciary Committee, indicated that after getting beyond the budget, the tax proposals, that they will move on H-1B. But the sense I got from the reported commentary was that this would be a way to elicit the Democratic Party's support, because there are segments of the Democratic Party that are very unfriendly to the H-1B. Senator Durbin, Senator Sanders are both not enamored of the visa category. And so I'm not sure that those would lead to the kind of economic incentives, both and advantages that I've tried to describe earlier. I think those would just weight down the H-1B with all the more restrictions. I might add that there are misperceptions about involuntary servitude in the H-1B, because we have something called portability, where one, if they're not happy with their employer, can move to another employer rather easily. There is also a proposal, as I said, that you could start your own startup. I'm not a proposal, a regulation now. And so there are advantages to the H-1B that allow for economic prosperity to manifest if they've just give the category some breathing room.
Yeah. So one last thing I just want to ask you, your current firm, the Alto, does global mobility. You have partners that help people move throughout the world for work. What has been the experience? How do people perceive sort of this U.S. system for visas, say, compared to moving to Canada or Australia or the UK or, frankly, any other country in the world?
Well, I'm not an expert in all these other domains, but I will tell you what I understand is that many different countries look at immigration quite differently. Many have adopted, for example, digital nomad admissions policies or visas. I've actually, with the Cato Institute, proposed last year that we adopt in the United States a digital nomad admissions policy for business visitors and tourists whose primary purpose is a legitimate visit, but who may have to log on to their laptop to find out what's happening at the home office abroad. There are many different countries. There are merit-based systems. There are point systems in other countries. But they have a variety of changes. And oftentimes there's a delegation of authority to the governmental immigration agency to change the system on the run as economic factors manifest and changes are warranted, which is possibly better than what we have. There are a number of other things I think we could do to fix the system. I mean, one is interesting, and I've thought about it a long time, but it's even more interesting after the Supreme Court decided to eliminate what is called Chevron deference in the Loper-Bright case. What that case will mean is that multiple federal courts, and there are 1,000 federal judges, can have their own opinion of what the law is. And that may create chaos, just as we have in the removal context, multiple opinions of what the law is in the various circuits. I think that may be a motivating factor for Congress at last to say, let's have an Article I immigration court. And maybe that would take some of the pressure off the federal courts to focus on non-immigration issues and at the same time have a harmonized view of what this decentralized immigration system ought to mean. What the law is different according to the Department of Labor, according to the Department of State, according to the Attorney General, and according to DHS. And so I would think maybe that would be a good solution, is let's at last have a harmonized body of law in an Article I court. I would also think that we should have more due process in immigration and have access to counsel, which is not allowed at the border or in consular officers to any full-fledged degree.
Yeah. Well, there's lots of things that we could talk about the immigration system. And Angelo, you are not only somebody who's been doing this a long time, but clearly has been thinking about it a long time. So thank you very much for joining us and taking the time to share your perspective.
Thank you. It's been great fun.
So we'll take a short break, and when we return, we'll speak with Jeremy Neufeld from the Institute for Progress about his recommendation on H-1B visas. Stay tuned. And welcome back. I'm now joined by Jeremy Neufeld, Director of Immigration Policy at the Institute for Progress. IFP is a nonpartisan think tank in Washington focused on innovation policy, specifically to accelerate and shape the direction of scientific, technological, and industrial progress. Jeremy has extensively researched the H-1B system and recently put forward a detailed policy analysis on why the current lottery system may not be the most effective way to allocate visas. His report is titled Talent Recruitment Roulette, Replacing the H-1B Lottery. Jeremy, thanks for being here.
Thanks so much for having me.
So let's dive into your ideas. Your paper argues that awarding H-1B visas by lottery is inefficient and undermines the program's potential for economic benefit to the United States. Could you walk us through why you believe the current random selection process is so problematic?
Yeah, sure. So the H-1B system, as you well know, is our flagship high-skilled recruitment program. Most people who are trying to stay after they have had a student visa will stay on an H-1B if they're able to. And most of the people who are getting employment-based green cards, the way that people can stay permanently, are coming from an H-1B visa. So this is really central to the way that we are recruiting high-skilled talent. But there's far more people each year who are registering for H-1B workers than there are visa slots available. In the most recent year, there were over 470,000 employers who were registering for workers, but there's just 85,000 cap subject slots for the private sector. And essentially what we're doing, instead of trying to pick out which of those workers is going to be contributing the most to our economy, to innovation, to science, we're instead gambling on them, giving everyone a lottery ticket and issuing them out at random, which means that world-class talent, the people who are going to be creating jobs, coming up with new products, they have essentially the same odds at getting a visa as entry-level IT workers or other kinds of more replaceable roles. So a biochemist who's going to produce the next life-saving drug is going to get about the same chance as an acupuncturist. And that seems insane to me. We all know the success stories and the massive contributions that high skilled immigrants offer to America. 21% of Fortune 500 companies are founded by immigrants. 36% of all U.S. patents are attributable to immigrants. But the immigration system isn't designed to try to maximize those benefits or pick out the people who are going to be contributing in that way. And simply put, it's not selecting the best talent, and we could be doing a lot better. And then I think it gets even worse than that, because not only are we not selecting among the best people that are applying, we're also creating really bad incentives for the people who are trying to use this program. Because people have about a 20% chance of actually getting a visa for the person they want, a company who spends a lot of time identifying the perfect person for a niche specialty role has no guarantee that they can actually bring that person in. And so it disincentivizes talent identification and talent recruitment. It favors a business model of instead of trying to find the best person for a job, of spamming the H-1B system with as many applications as possible. And then it also has a lot of waste, where a lot of people are spending time trying to hire international talent for jobs that they're never going to be able to get a visa for. And so I think for all of those reasons, we could be doing a lot better. And one of the things I talk about in the paper is that just by changing the way we're awarding visas, we could probably get twice the amount of value from the H-1B program just by replacing the lottery.
So, in addition to all of those issues, your paper takes an economic analysis approach to the alternatives to the lottery. Can you talk about how you designed this analysis and the different proposals you modeled?
Yeah, sure thing. So there's been a lot of debate over the H-1B lottery, but there's little like rigorous quantitative analysis that actually compares what the alternatives would look like, how they would affect who's coming in. And so I really wanted to fill that gap. And so to do it, I submitted a FOIA request to the Department of Homeland Security, and I was able to get back from USCIS 2.5 million I-129 petitions, which are the petitions that employers file for H-1Bs. And this is completely new data. It has never been analyzed before. And so what I do is, of those petitions that I got back, I take out the petitions that are filed on cap subject H-1Bs. So I'm only looking at the ones that are actually going to be subject to the lottery. And not to get too in the weeds, but there's not actually just one lottery. There's actually two lotteries, because people who have advanced U.S. degrees get access to a set aside of 20,000 additional visas. And with a little bit of work, I can essentially separate these out. And so I have a random selection of both of these applicant pools. And then, because I have an actual random sample of what of the people who are applying for H-1Bs and are entering the lottery, then it makes it very easy to simulate what alternative mechanisms would look like. If we know who is the characteristics of the people who are trying to get H-1Bs, and then we're testing how they would get awarded under different mechanisms, then we can actually learn a lot about who would be receiving them under different proposals, what their education looks like, what kind of employers they are, what kind of education they have. And I do that for three basic proposals. The first is a compensation-based proposal. And so this is pretty simple. It simply ranks petitions based on how much employers are promising to pay the H-1B worker beneficiaries. The second is the proposal that DHS put forward in 2020, which I call a seniority-based system. We can get a little bit more into this, but essentially, this would not base the ranking on compensation alone, but something called Department of Labor wage levels, which are supposed to correspond to the amount of experience that's required for a job. I think it's a little bit misleading, the way it's often been called a wage-based system, because it doesn't actually compare wages across occupations. It just looks at how much people are paid compared to other people in the same occupation and area. And so what that essentially means is that someone can be paid much less than someone in another job, but be a higher wage level if they're their later career within their occupational area. So that's a seniority-based system, and I look at that. And then the third proposal that I model out is the allocation system described in Section 104 of the bipartisan H-1B and L-1 Reform Act, which is a bill that's been introduced in Congress a number of times over the last years. And it does a lot of different things on the H-1B and the L-1 system, but one of the sections replaces the lottery, and it creates a tier ranking, which mostly favors advanced STEM degree holders from U.S. universities, but it has 8 different tiers, and it awards visas in going down the tiers until all the visas are exhausted.
So, okay, that's a very complicated methodology. First of all, I'm impressed that you were looking through more than 2 million different cases. So, what did the outcomes say? What were the outcomes of this, and how did those different proposals fare?
Yeah, so the top line outcome is that the current H-1B system is really underperforming, that we could about double the economic value. We could increase the average wages which are being paid to H-1Bs by over 40% without changing, again, the number of visas. So it's not really a problem with the current applicant pool, although we could probably do better with that. But quantitatively, we're just really we could be picking people a lot better. So the proposal that comes out the most ahead is a compensation-based system. And as I mentioned, this is just awarding H-1Bs in the order of job offers. And I think one of the things that it suggests is we get a lot of benefits out of it. So it ensures that the median compensation that's offered to new H-1B cohorts is increased more than any of the other proposals, increasing the H-1Bs that would have been issued over the last 5 years from $88,000, which is what the actual H-1B cohorts were paid. It would have increased that up to $130,000, and that translates into a 90% boost to GDP over 10 years. It also really shifts the composition of who's receiving H-1Bs. So currently, outsourcing companies, these companies that have specialized in securing a large number of H-1Bs and then contracting them out to third-party employers, they currently gobble up about a third of the H-1B slots, and a compensation-based system would cut the number of H-1Bs going to those employers by half. And for employers that have the majority of their workforce on H-1Bs, it would cut the number going to those employers by 80%. And we think that's probably a good thing because those employers tend to pay a lot less and be filling roles that are less specialized. One result that was actually quite surprising is that it slightly boosts the retention of people who are already here on visas, like student visas. And so one of the things that is included on these petitions is whether someone is changing status from an existing status. And here we see that the share of visas going to those people slightly increases. It's not a big difference, but it's also not trivial. And then the last big benefit I'd point to is that it about doubles the share of visas going to PhD holders. So it significantly increases the educational attainment of the people we're giving H-1Bs to. And then, yeah, actually, that was not the last one. The last thing I'd mention is just that it also increases the certainty. So once people know that they can look at the last year and know that the lowest H-1B person was offered salary X, they will know in the future whether or not a job offer is likely to receive an H-1B. And so it reduces a lot of the waste of registrations being filed for people who aren't going to get visas. It gives a lot of information to the government about the real value, not just by the number of people applying, but like how much people are actually willing to pay. And it's much more likely to help U.S. workers because it puts a lot of upward wage pressure on wages. Because if you pay people more, you're going to be more likely to secure a visa.
So, talk about how the other two options that you modeled came out: the seniority system and the system from the bill that prioritizes graduates from U.S. universities, STEM degrees, and other things.
Yeah, so the seniority-based system, which DHS proposed in 2020, also does pretty good. It looks pretty good compared to the status quo. So there, we're still increasing the wages that are going to be paid to H-1Bs by a lot, but it's not. But it's only about half of the benefit that we would get from a more compensation-based ranking, and that is really because it implicitly favors later career people over higher paid occupations. And so in this example, someone who's a really experienced IT worker or a really experienced acupuncturist is going to be favored under a seniority-based system relative to an early career AI researcher or an early career biochemist, even if those people might be earning more in absolute terms, just because those occupations themselves are so much more productive than those other occupations. So the seniority-based system really favors late career people and seniority, but it still would significantly increase the economic value of the program. It would be an improvement, but it could be it could set back the efforts to prioritize workers going to the most innovative fields or it might also set back efforts to recruit younger, early career people who are going to be mostly paid at the lowest wage level in high-paying occupations. The most underwhelming proposal is the Section 104 from the H-1B Reform Act. And one thing that I found was that in 4 of the last 5 years, all of the visas would have gone to the top tier ranking in that list. And so there were more people who applied with advanced degrees from US universities than there are visas available in almost every year for which I have data. And so essentially so that system isn't really replacing the lottery. It is creating a new lottery only for people who have advanced degrees from US universities. That's probably still better than our current system in pure economic terms, because we're going to be increasing retention. We're going to be increasing the educational attainment of the H-1B workers who we're giving visas to. But at the same time, we're essentially cutting off the H-1B system for talent who doesn't have education in the U.S. And a lot of that talent is going to be is very highly paid, very highly skilled, and so that has the smallest economic gains compared to the other proposals.
So, other than the economic benefits of these possible changes, what other benefits do you think these types of reforms might have for U.S. employers, the immigrants looking to work in the U.S., and U.S. workers?
Yeah, so I mean, I think one big benefit is that US workers will be able to trust that the H-1B system is not being used for cheap labor and being used to replace them. I think we've all heard of these stories of companies bringing in H-1B workers, having US workers train their replacements, and then firing the US workers. And there's a lot of debate about how common this is. I personally don't think this is very representative of the program writ large. I don't think this is the way to think about what high skilled immigration generally looks like, but it's definitely true that this sometimes happens. And getting rid of the lottery and putting in a system that really establishes a salary floor on H-1Bs that forces employers to compete by paying more. All of these things, I think, would really build in integrity into the system, prevent abuse, however common it is, and make it much more likely that this is a program that really is bringing in people who we need, who are going to be contributing a lot, and aren't going to be undercutting US workers. Another big benefit that's not purely economic is that it creates a lot more certainty, both for employers and for the immigrants themselves. Right now, like I said earlier, people are trying to build life decisions and business decisions based on the prospect that maybe they'll get a 20% chance of winning this lottery and either being able to come to the United States on H-1B or stay in the United States, or be able to hire for a role as they're trying to build a business. And they have no way of knowing whether that's going to pan out. Replacing the lottery is with something that has more predictable outcomes, is going to create certainty for those people. People are going to be able to make decisions better because they'll be able to know whether a petition is likely or not to secure a visa. And then the last thing I'll say is that it also will really change the incentives behind the H-1B to put a lot more effort on talent identification and recruiting, because currently that's not really worth it, because you can't be guaranteed to bring in a particular individual. And so I think it will also change some of the dynamics there.
Yeah. So let's think about maybe some of the ways that this is not necessarily the best. I want to start with defining. So in the first part of this episode, we interviewed Angelo Paparelli, a longtime immigration lawyer, and he said, "Look, the easiest way to get rid of the lottery is get more visas, right? The reason we have a lottery is that there's so much more demand for the visas than their visas are allotted each year, and so the agency has no choice but to select amongst them in some manner. By looking at the different options on the lottery, I assume that you're not necessarily saying that increasing the number of visas is bad. You're just saying as long as if we have to have a lottery, these are better ways to do it. Am I correct in understanding that?
Yeah, for any number of visas, whenever there's going to be more people who are eligible and want to come, you're going to have to make decisions about how to award them. I think of the question of how many visas should we be giving out is fairly orthogonal to the question of how should we be giving out the ones that we are going to give out. We would probably want to be awarding visas by, I would say we would want to be awarding visas largely based on compensation, whether we had half as many visas as we do now or 3 times as many as we do now. And the basic mechanisms that would explain like why prioritizing the people who are going to be contributing most would apply at any level. One additional point is that awarding things based on compensation actually creates a lot more information for lawmakers in setting the level of visas. So right now, lawmakers look at the H-1B system, and depending on maybe their politics, they can see two very different things. It's a little bit of a Rorschach test. They can see a program that's bringing in replaceable IT workers, which is true, or they see a program that's bringing in the best and brightest startup founders, people who are inventing great new products, which is also true. And then they can fight over how to set levels, and they don't come to an agreement, and we end up stuck in the status quo. However, if we had a system that awarded visas based on compensation, lawmakers could look at the people applying each year, and they might be able to see that the lowest paid person is being paid much more than when the system was put into effect. They might see that last year the lowest paid person was paid $150,000. Next year they were paid $170,000, and that might be a signal to lawmakers that that's a real need to increase the number of H-1Bs that right now they don't really have. They can look at the number of registrants, but that might be a signal that there's more demand, but it might also be a signal that there's more demand at lower quality. But once you incorporate some amount of price into what lawmakers are able to observe, I think it creates a lot more information that can then be used thoughtfully to choose how to set the levels of immigration.
Yeah. So in the past, critics of compensation-based systems worried that focusing exclusively on higher salaries could disadvantage younger or early career workers, especially those in lower cost of living areas or at startups, or important areas of specialty that may not pay as much because of the whatever salary structures are engaging, thinking academia for one. How do you address those kinds of concerns?
Yeah, so I really share these concerns. I think from both an innovation perspective and a fiscal perspective, we should really want our immigration system to be selecting for young early career workers who are going to be contributing a long time to the U.S. And we want people who are going to make their major contributions here rather than getting later career people after they've already made their most critical contributions. So I think this is a really important concern. I think the extent to which compensation-based ranking would set back retention or recruitment of early career people has been overstated. So we didn't have that much data before. And I think one thing my paper offers is the first real quantitative assessments based on all I-129 petitions. And one way to think about this is that there's two real effects going on. One is that moving toward compensation-based ranking will privilege people who are earning more because they're later in their career. But it also cuts against employers like the outsourcers who are not bringing in early career people and are gobbling up visas for relatively lower paying jobs. And the magnitude of those effects, I don't think anyone really knew before. But I think one thing that my modeling is able to show is that that second effect, cutting against the outsourcers, is much stronger. And so we actually will slightly increase the retention of student visas, for example, with a compensation-based system. So that's the first thing I would say. But the second thing I would say is that I still think that the benefits of bringing people in at the beginning of their careers is quite high. And so the recommendation that I make in the report is actually not to use the pure compensation-based system, but is to make a couple of adjustments to try to respond to these very legitimate concerns. And so I basically suggest three major adjustments. The first is to adjust for age, because again, from a fiscal perspective, we'd much rather a 25-year-old making $140,000 to a 63-year-old making $150,000. Because even though that 63-year-old might be being paid slightly more now, they're going to be contributing for a lot less time. And when the younger person is in the same place in their career, they are very likely to be paid much more. And so if we adjust for age to try to account for the likely contribution over the course of a worker's time in the labor force, I think that would be an important adjustment. And then we can also adjust for geography by using the regional price parities of the states that the worker is going to be working in to make sure that lower cost areas aren't unfairly excluded. And then the last thing is one reason I've been talking about this as a compensation-based system and not as a wage or salary-based system is that startups and other companies that often are offering variable income or equity packages as part of their compensation packages. In some ways, those companies might be some of the most productive companies and those with the most promise. And we don't want to unfairly exclude them by only considering something like salary.
Yeah, it's worth pointing out to our listeners, the law and regulations regarding H-1B compensation require that the H-1B worker be paid the higher of the prevailing wage or the actual wage in the area of employment for their occupation. But that wage really is only allowed to be salary. Other parts of the compensation package, including any sort of incentive payments like bonuses or stock options, which are not guaranteed, cannot be counted under the regulations to meet that salary requirement. So even some very highly paid jobs, I'm thinking in financial industry, for example, have some of these incentive things built in, but they cannot be counted. Even though they're standard in the industry, they cannot be counted toward the required wage. And that does require some recalculations for H-1B employees by employers. And your point about startups oftentimes are, a startup owner may forego a salary for a period of time in favor of understanding that at some period of time, this company will be profitable and they will make more money. So it's definitely something to think about, maybe. And to your point is to not just look at salary, but look at total compensation as another way. But it's interesting in saying that there are some adjustments from a pure compensation based system, you know, and looking at the legislative option that considered lots of different criteria. So we're thinking about there are other factors that we might want to look at, like degree level, if they come from U.S. universities, STEM fields, critical shortage areas, for example, medical professionals maybe. Do you see a merit to kind of a blended system that could look at these different types of criteria? I mean, you mentioned you modeled some of this, but one of the things that strikes me is the more kind of criteria you start putting in there, this sounds very much like a points-based approach, right? If we look at our friends to the north in Canada and other countries that have this approach, they look at lots of different kind of criteria and say, okay, we're going to give so many points based on salary, based on age, based on specialty, based on educational level. How do you feel about that being sort of a step toward that kind of a system?
I think any serious points-based system would be a vast improvement over the status quo. The challenge, I think, is that a points-based system also needs to be very carefully designed, especially if it's going to actually exceed the benefits of using something like compensation, which I think is really our best signal metric and signal for the kind of innovative productivity contributions that we care about for the economy. And I think education is a really great example of this. So there's a question both of we want to pick signals that are actually correlated with success, and we want to avoid creating bad incentives. And with education, I think we see both of these things. One thing is that education might not, in fact, be a great indicator of success. I think about Bill Gates, who very famously doesn't have an undergrad degree. I know one of the key technical one of the key people on the technical team at Anthropic doesn't have an undergrad degree, and so focusing too much on credentials could in fact set us back from recruiting very productive people who are going to be making very major contributions. And the other thing I worry about, which also I think education is a good example of, is creating incentives for people to try to just tick boxes to gain points. And so you might have someone who, if they immediately entered the private sector after graduation, for example, they might be earning enough to get a visa and start their career and start making the contributions that we care about. But if they needed to accrue additional points by getting a useless master's degree, maybe they would delay their career and invest in that instead. And that might not be a good use of their time, and it might undercut some of the contributions that they could make. And then it could also create a bad incentive for universities or other degree granting institutions who might view the possibility of helping people secure immigration status as a bit of a cash cow and offer very expensive master's degree programs or other degree programs. And I think this is one thing that Canada and the UK have run into issues with, where they have visa mills that are awarding degrees to help people get status in their countries, and it's reducing the quality of the signal that education is sending to their point systems, and it's therefore also reducing the quality of the people they're recruiting in the first place. So this might sound very negative on points-based systems, but I like points-based systems a lot. I just think we have to be careful about how we design them to avoid some of these pitfalls. But also the status quo is so poorly designed that even with some of these problems, it could still be a big improvement.
I think that just goes to show there's no such thing as a perfect system, right?
Yeah.
And every system is going to have some flaws. So finally, H-1B reforms often get stalled by political or practical challenges. Under the current Trump administration, the Congress that we have, do you see a viable path for adopting any of changes to the lottery system? And what do you think it would take for Congress or the administration to act?
Yeah, so I think adjusting the lottery can actually unite a strange coalition in American politics. And I think it brings together some unlikely bedfellows in the immigration debate who wouldn't usually sign on to an immigration reform. So on H-1Bs, I think you have everyone from the traditional pro-business side of things who would want to favor merit-based reforms to bring in the most productive people. You'd have people associated with labor who would support things that would make it much less likely for workers to be exploited and be paid low wages, to people who care a lot about how this affects American workers, and to prevent, who see the H-1B now as a source of cheap labor. And replacing the lottery seems like it could appeal to all of those groups. And given the recent H-1B debate that has been rocking the Republican Party, this also seems like something that kind of addresses both concerns. On the H-1B skeptical side of things, this would be something it definitely doesn't eliminate the program, but it might eliminate the particular parts of the program that they view with the most suspicion, the outsourcing companies, the lowest paying H-1B jobs. And on this side that I think correctly recognizes that H-1Bs can be an important ingredient to American dynamism and American success, the Elon Musk, Donald Trump wing of the party, I think they should want the same thing, which is to turn the H-1B system into the economic engine, which it really could be. And if they're happy now with some of the performance of the program, and they already see it as a powerhouse, which it is, knowing that they could get twice the power out of it should be a no-brainer.
Well, I think we'll leave it there. Thank you so much, Jeremy, for sharing the results of your report. If people want to read this report for themselves and find more about the work you do, where can they look online?
Yeah, so our website is ifp.org, and this report in particular is at ifp.org/H1B.
And are you on socials that people can follow you if they want more of these insightful thoughts?
Yes, I am on Twitter at Jeremy L. Neufeld.
Great. And Neufeld is Neufeld. We'll spell that out. Thank you so much for joining us on This Week in Immigration.
Thanks so much for having me. This is fun.
And that's a wrap on this episode of This Week in Immigration. Stay tuned for our next episode in 2 weeks. In the meantime, one last reminder to subscribe, rate, and review this podcast on Apple Podcasts, Spotify, or your favorite podcast platform, and share it with your friends and colleagues. You can also find more information on all the issues we discuss here on the show at bipartisanpolicy.org/immigration. You can follow the Bipartisan Policy Center on the X platform at BPC_bipartisan. You can follow Theresa Cardinal Brown at BPC_T Brown, and you can follow me at Jack Malday. Send your comments and feedback to us by email to immigration@bipartisanpolicy.org. I'm Jack Malday. This Week in Immigration was created and executive produced by Theresa Cardinal Brown. This episode was written by myself, Theresa Cardinal Brown, and Diana Wang. Joshua Joe is our audio editor. Talk to you next time on This Week in Immigration.